We are on the record in the matter of the state of Michigan the city of Wyandotte versus Robert Allen, 241508 A and B. I'm sorry, A, only A. Good morning.
Before we begin, may I very briefly approach?
Okay.
With the updated PSI report, there's still one conviction that I was curious if I may be able to look at the CCH that we are not able to be provided. Because I think kind of the court copy would have it. She did remove a number of those convictions we had mentioned were dismissed, but there is still one.
Which one is that?
03 breaking and entering.
Okay.
I went to go look through both Wayne County and the Cold Run Circuit courts and can you find any record of that conviction?
Okay, I show 97, 2004, 99, that was just last, 2004, 2004. 2013. (2019), that one was removed, right?
Yes.
Oh, well, that's from a different court. Let me look. That's the state of Michigan. Thousand. 2000. Pennsylvania. Just, I'm not showing anything for free. I'm not showing anything on here.
Okay, I just wanted to
So,
representations that left it in.
right.
Could have just been over assessments.
Yes, so let me go drop this to Michelle so she can confirm that. That way we just have everything accurate.
Okay, yeah, because I just wanted to.
Yeah.
Good thing. I can't find anything of it. And he just told me that it's
Yeah, and I'm not sending anything to CCH. So let me just chat with her real quick and then we'll be right back. Okay, just a moment. And we are recalling the matter of the state of Michigan versus Donald Baker, 25482.
Mr. Table.
What's that?
It doesn't say what.
You're correct. You missed the table. That's what she said. Yeah. Good morning.
P 30758 on behalf of Mr. Baker. Mr. Baker, please put your name on the record.
Hold on. Mr. Baker has to unmute first. And I don't think he understands that he can push that button. So I think we have to wait the 30 seconds for it to unmute on its own.
Okay.
I think so. Bobby, can you give me a felony court appointed form, please? I'll just complete it. This is arraignment only, correct, counsel?
That's correct, Your Honor. And it appears that he has been read out or based on about 180 days.
That's correct. I see the 180-day notice that was dated August 4th of this year.
Restaurant.
Thank you very much. All right, sir, your name for the record, please. Mr. Baker. Mr. Baker. Mr. Baker. Am I muted? No. Mr. Baker. Mr. Baker, will you please state your name for the record? Mr. Baker, can you hear me?
Yes, I can hear you now.
Okay, please state your name for the record.
Donald Baker.
Okay, very good. And counsel?
You're on John Gold for P 30758 on behalf of Mr. Baker. Mr. Baker is here doesn't via Zoom from the Jackson prison for the purpose of remaining. I have discussed charges with Mr. Baker. At this point in time, he would waive a full reading of those charges, stand mute to the charges, and ask the plea of not guilty to the injury.
The court will waive the formal reading. Sir, you do have the right to have an attorney represent you. If you cannot afford one, you may have one appointed to represent you. And the court has signed a petition for appointed attorney for felony matters. And the court will note defendant is in custody at Robert G. Cotton facility. The court will also note, sir, that you do have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights, sir?
Yes.
The court's going to enter a plea of not guilty for purposes of the arraignment. Schedule this matter for probable cause conference on October 9th at 8:45 a.m. And then counsel, we have to address bond, but I'm not presuming your client is as your client's in Robert G. Cotton facility. I presume he's not going anywhere between now and next week.
If I may,
Yes.
he's in that facility on his statement to me that on a previous occasion, he was charged in Livingston County with this identical charge. He has now been sentenced for, I believe, 37 months to 37 months to 15 years, I believe. That's why he's in the jail. The reason he did not appear originally, Your Honor, was because he was in the Cotton facility as of July 3rd. In fact, he was supposed to be here. For those reasons, Your Honor, I would suggest that at least some reasonable bond under the circumstances be set, though he is going to be incarcerated or injured.
And what is it he's in custody for again, counsel?
He has told me that he pled guilty or was found guilty of charges dealing with, larceny of the building, and as well as the stolen property charge.
From this case, or
That's what he said, Your Honor, but that doesn't. I told him that would be an issue that had to be raised by his felony attorney. That's why I stood.
well, perhaps because your client's been charged with a number of larceny in a building charges, perhaps your client is getting those confused.
He may be wrong.
Because
Ma'am.
I was going to give you an opportunity in just one moment. But what I'm looking at is I'm showing there are sentencing dates in 2022 for 2 to 4 years, 2023, 1 year, 6 months to 4 years. That was February of 23. Also a larceny in a building.
Correct.
Another larceny in a building with a HAB 4th, July 11th of 2023. 1 year, 3 months to 15 years. Those were all prior to the offense date on this one of March 31st of 25. So, and then there's obviously larceny in a building, habitual offender, 4th offense back from 2011. But
I believe the offense date on this one was March 1st.
well, I'm showing on here March 31st, but let me March 31st. Yes. Okay. Okay. Yes, Mr. Baker, what would you like the court to know?
Ma'am, I was convicted on this charge, this case, July 31st. I got 47 months to 15 years. And then after I got convicted of this case, y'all came up with a court date for August the 1st on this matter. I had already been convicted January 31st of this matter. I'm in prison for it right now. A blue Cherokee I got caught in Livingston County in.
All right. Well, here's let me look at something here. Okay, Livingston County was April 1st of 25 was the arrest segment. June 27th shows the judicial segment whereby your client pled guilty to felony receiving, concealing stolen property, motor vehicle, second offense notice, and felony financial transaction device, 2 counts of those. And then that shows 47 months to 15 years.
That's correct.
All right. Now,
That's why he's in Jackson right now.
then there is one from Sixth Circuit from 2023, February of 2023, larceny in a building your client pled no contest to, showed 18 months to 4 years.
That's correct.
So I'm not showing anything yet as it relates to
This matter.
this matter.
Mr. Baker has made it to me that the charges that he pled Livingston County with the 47 months was this case. I'm just telling you what he said. I have not seen the write-ups for any of that information. Where I've indicated that set this for a PCC. If there's a double jeopardy issue, then that will be addressed at a later date.
Receiving and concealing.
So you have a number of those charges in a number of jurisdictions. So it's possible that somewhere that was confused because I'm not even showing anything in the charge segment. But that may be because your client hasn't been fingerprinted yet on the Wyandotte felony. It says
Excuse me, Your Honor, can I say something?
Sure.
just one moment, sir. So the warrant was authorized by this court, authorized on April 4th by the Wayne County Prosecutor's Office of 25. And then in this manner, June 16th of 25. And that was the complaint and warrant. And then this was never, I don't even think this was ever on the docket here. It was on the docket for August 7th.
That's correct, Sharon. That's
So
true.
I understand that, but my point is that this was never on a docket in this court to have been addressed with Mr. Baker when he was in custody at Livingston County. So perhaps he may be mistaken as to these charges. So that's something, sir, your attorney is correct. Your attorney that will represent you at the next stage of the proceedings will address.
Okay, ma'am, can you make sure I'm in person? Can you make sure I'm in person? I can have all my paperwork and stuff. Cause I'm not confused. I know what's going on. It's only one person. I think her name was Sharon or something. I've been convicted of this crime already. I'm doing 47 months for it. The Wyandotte case, I got all the police reports. I got everything. I've been convicted of it. The car came up missing in the parking lot, some parking lot at Henry Ford Medical Center or something like that. I've been convicted of the crime. I pleaded guilty to the crime along with my financial transaction advice. They charged me with receiving and concealing stolen motor vehicle, gave me 47 months. So
Well,
I would like to be here
interestingly
in
enough, your
person.
client's accurate with what the police report says.
I agree.
Y'all tried to press charges on me after.
Hold on. Let me clarify, sir. Let me clarify. The court does not press charges. So when you're saying y'all press charges, the court does not do that.
Okay, where they put a warrant out on me after I was already in custody. I went to jail April 1st in Livingston. After you found out I was in jail, you put a warrant out. The court put a warrant out for me. They never came and got me from Livingston. Livingston ended up convicting me, giving me 47 months.
That may have
for the same crime.
Hold on just a moment. However, sir, let's clarify. You were on parole for larceny of a building out of Lansing, because it shows you were a parole absconder from Lansing Tether Unit. So perhaps there was a plea of guilty on the tether violation or the parole, or maybe you were remanded back to custody for that violation. But I'm unsure of what that is. And I can request that it be in person, but I don't know if MDOC will transport you for a PCC. That's up to them.
Okay. I would like all my matters in person, ma'am. This Zoom don't help me with nothing.
All right.
All right,
We'll do it
thank
in
you.
person. You're requesting in
thank
person and not consenting to Zoom for the next proceeding, then we'll do it in person. No problem.
I grabbed the wrong envelope. I could have brought it to you. I grabbed the wrong envelope.
We gave the PCC is the night guard sheet.
Yes. So the court will order no contact with the victim in this matter. And the court's going to also, you're serving time, you're currently in custody, but the court's going to order a $50,000 cash bond so that we have a bond listed. And I did put in here, sir, that you're requesting in person. So we will see you next week.
Okay, thank you.
Thank you. Have a good day.
You too.
What's that?
Square there. Yeah,
Okay. Let's go on the record in the matter of Mr. Goldman. I have to handle them in custody first, and then I have yours. I have the answer to your question as well. Okay. Let's go on the record in the matter of the State of Michigan versus Frank Christopher, 2511130, 251394.
Good morning, Your Honor. Kathleen Tulas appearing on behalf of Mr. Christopher. I was
Thank you.
appointed to his second case this morning.
Oh, very good. I'm glad they were very quick about that. Okay. All right, Mr. Frank, your name for the record, please.
Frank Christopher, Your
Mr.
Honor.
Christopher. Shoot, I'm so sorry. I'm sorry. Can you repeat that, sir, please?
Frank Christopher, Your Honor.
All right. And counsel, today is the date scheduled for the probable cause conference on the new case 1394. And then we reset the preliminary exam last week to be a PCC on this date to coincide with 25-1394.
Yes, Your Honor. At this time, I am asking that both matters be set for an in-person examination next week. The prosecutor has said that he has sent me all the discovery on both cases, so we should be prepared to proceed next week on both cases. Also, I would like to address bond for Mr. Christopher.
Okay, so let's do October 9th on both matters.
Your Honor, I have a court date in Third Circuit on October 9th.
Well, then counsel, we're going to have to do this on the 16th.
They won't be able to do anything until you're done. They're waiting for you. Could we go any sooner? It's not possible. I don't know.
Who's waiting for this court? The Third Circuit Court is waiting for this court?
Yes, that's what he said last week.
Your Honor, the probation, Mr. Christopher has a probation violation. Nothing will happen on the probation violation until this case is resolved. Both of these cases are resolved.
Okay,
But if he has a court date there next week, they probably will still want him for that court date.
so counsel, can you communicate with the probation department to have them move that date to another date so we can have this exam on the 9th? Because otherwise it doesn't seem to be productive to have Mr. Christopher go to the Third Circuit Court for a probation violation if it's pending the results of these two matters here in this court.
I can contact the court and ask, Your Honor. We can set this for next week, and then if there's an issue with it, then we'll schedule it for the 16th.
Okay. So counsel, can you just please communicate with us so that we know what's happening with that?
Yes, Your Honor. As soon as I have a reply, you'll know.
All right, thank you. What time, Allie?
Can we do it at 11 a.m.?
I was actually just thinking the same thing. So let me see what Allie says. So, well, okay, 11 a.m. We have one scheduled 11 a.m., one at 11:30, and one at 1 already that day. So whichever is ready first, we'll go, I guess. And then, so counsel, a couple things. It's also a bond violation hearing as well, because your client was out on bond on a tether, and because he received new charges, your client, it's a violation of his bond as well. So we can adjourn the bond violation hearing also to next week. And counsel, I'm going to presume that the bond that you're wanting to address is the bond that this court ordered on case 251394, which this court ordered $100,000 cash bond, no 10%, no surety, not to possess or consume any alcohol or drugs. Is that the one you're asking about?
Yes, Your Honor.
Okay.
I do believe that bond is excessive. I do not have all the discovery, so I do not know everything about the new case to argue any facts of that case. But Mr. Christopher has been trying to get his drug issues under control. He was at Sacred Heart. I he has a very, very supportive family who support him totally and completely. I just ask if you would consider reducing that bond.
Here's the issue, counsel. Your client is currently on probation for a felony possession charge. He's on felony probation. While he's on probation, he's charged with possession of controlled substance and assaulting, resisting, obstructing an officer August 1st. This court, despite that your client was on probation, ordered $20,000 personal bond. Your client was to be tethered to treatment through the Wayne County Jail. I'm not sure what happened with that, whether he was tethered to treatment or not. Sir, were you tethered to treatment in August through the Wayne County Jail or no?
Yes, Your Honor. And then I went to Sacred Heart August 11th, and I was released on August 29th.
All right. Well, then while your client was out on bond, now he's charged with another felony possession charge. And that is why this court ordered $100,000 cash bond, no 10%, no surety, because quite frankly, it's in your client's best interest and for his own safety and health to remain in custody at this point. The court will also note for the safety of the public as well. So for those reasons, the court's not going to reduce the bond. The court's going to continue bond and conditions.
Your Honor, may I speak a second?
Yes.
I don't know if it's relevant. I just wanted to let you know what happened at Third Circuit last week. The probation department recommendation was for me to do in treatment, return to Sacred Heart. And that's all I'm hoping for, is to get help, more help. But I don't know if it matters. I just wanted to let you know that that was their recommendation, and also that I would be, that doesn't mean the judge will take it. And also that I would report twice a week when I did get out of jail or prison, whatever. And I would report twice a month, every month, and I would be drug tested every time and all of that. I just for your information, that's all. I'm sorry.
All right. Thank you, sir. And the court will note that quite possibly could be something that occurs after the preliminary examination, but I am continuing bond and conditions today.
Thank you, Your Honor. Mr. Christopher.
Thank you.
Mr. Christopher, I do have a jail visit scheduled tomorrow so we can discuss the new case.
All right. And then just one more thing. Witness and exhibit lists are due October 6th. We'll see you back on the 9th. Thank you.
Thank you. Everyone have a wonderful day.
You as well.
Thank you.
Thank you.
Thank you. So on the record in the matter of the state of Michigan versus John Christmas II, 251330.
Very good.
I'm done. I don't know what they touched on. I hated it.
Can you indicate on there the adjourning the bond violation to next week as well, please? Yeah. Thank you. All right. Mr. Christmas, your name for the record, please.
John Christmas II.
All right. And counsel, today's the date scheduled for the, it was scheduled for an exam last week. And then your client wanted a different attorney. And so this court adjourned today for PCC so that your client could retain counsel and then counsel could be brought up to speed with discovery.
Excellent, Judge. And I do have the discovery now. I'm up to speed. And would the court entertain a quick oral bond modification motion?
Well, first tell me what it is we're doing with the PCC.
Oh, yeah, Judge. I got my discovery and me and the prosecutor had issued a signed order, stipulated proposed order to the court to set an exam date.
Okay. October 9th at 1:30. Right, Ellie?
Yes.
Okay. All right. And counsel, you want to address bond?
If I could, Judge, please.
All right. Bond is currently $250,000, 10% bond with the following bond conditions. That is there's no contact with the complaining witness in this matter. That's phone contact, text message, email, social media, anything of the like. That's Ms. Mandujano. Not to return to her home in Flat Rock, not to possess or consume any alcohol or drugs unless prescribed, no access or possession of firearms or any other weapons, not to be released without a GPS tether through the Wayne County Jail.
Thank you.
You're welcome.
In relation to that, Judge, my client reports to me no history of failure to appear. If danger to the community was a concern for this client, tethering would resolve that concern, Judge. Thirdly, the police report says that the Riverview police arrested him in Southgate, not in a hot pursuit. I believe that would have been an unlawful arrest, and so he would be unlawfully detained at this moment. I would ask that he be put out on bond for that issue. To be brief, also, as I'm sure the court's aware, domestic violence is notoriously spotty when it's prosecuted by the police out of any charge. So even though my client is presumed innocent under the law anyways, specifically with a charge like that, he should be presumed innocent. But particularly concerning in this case is that the complaining victim was so drunk that night she couldn't make a police report. The next day when she's interviewed by the police, she admits her memory may be affected by being in the police report in writing. She admits to hitting my client with a cord and punching him in the face.
Hold on just 1 moment. I need the prosecutor in here, please. Hold on. Is it? And counsel, your appearance, please.
Good morning, Your Honor. Mohammed on behalf of the people.
All right, thank you. And so Mr. Quartz has made a bond reduction request. Mr. Quartz, if you can start from the beginning again, just so Mr. Mohammed can hear all that.
I believe that my client, the Riverview police say in their own report that they detained and arrested my client at a substance located in Southgate. I believe they actually put the word Southgate in their report. That's outside of their jurisdiction. It wasn't a hot pursuit case. He would have at that point been unlawfully detained without a warrant. He would then currently be unlawfully incarcerated. I would ask that at least while that is brief, any evidence that would follow from that investigation, I would then argue should be stricken. But while that issue is being briefed, I would ask my client to leave another pending bond. Following that, according to the police report, she was so drunk she was unable to make a police report that night. That would, of course, go to her credibility. She admits the next day that her memory may be affected due to the drinking. She also admits in her police report that she hit my client with a sword and admits to punching him in the face. Now, one may presume that she was doing that in self-defense, but her quote is, she stated she punched the defendant in the face when he did not allow her to gather her additional items. That would indicate that my client was a victim of abuse that night. In fact, my client was making a police report with the Southgate police that night, which would give her a motive to lie and then press these charges. So for those reasons, I would ask that his bond be tethered. He has no history of failure to appear that I'm aware of. Plus, the danger to the community argument would be eliminated by tether. I'd also just like to quickly read in a one paragraph letter from his father.
No, I don't have that person here, so we're not going to allow that to be read right now. Do you have any further argument regarding bond counsel?
Gotcha.
Okay, Mr. Muhammad.
Judge, the people would object to modifying bond. I do believe it is appropriate. The defendant does pose a danger to the public. He has a previous conviction for operating while impaired, as well as a prior domestic violence charge. So based on that and the facts stated in the report, which people would object.
Counsel, who was the victim on the matter from Ypsilanti in 2016?
I believe that was another woman, Your Honor.
Not this individual?
That's my understanding. I don't want to misstate it to the court, but that is my understanding. I wasn't on the case.
Okay, Mr. Christmas, the conviction that you have for domestic violence in Ypsilanti in 2016, who was the victim?
Well, it was an ex-girlfriend that I don't speak to anymore that has tried to message me before about
Hold on, no, sir, I don't need any extra. I just want to know who the person was. I don't need any backstory. I just need the person. It's not this current individual?
No.
What about 2017? You were charged in Riverview for domestic violence. Who was the alleged victim in that matter?
I was not charged in that matter, ma'am. That matter was dismissed because that person was found incredible.
Sir,
So I'm not
again, you're not following my instructions.
I'm just
My
not understanding.
instructions
I'm
were,
sorry.
who was the named alleged victim in that matter?
Her name was Haley.
Okay, so not this individual. 2021, there was an assault and battery out of Wyandotte. Who was the alleged victim in that matter?
I'm not sure, man. I was not convicted of that. I'm not really understanding.
Sir, I'm aware you weren't convicted. I'm asking who the individual was.
The alleged victim was a gentleman.
That was my question. And then I believe there was also a time that you were before this court and your grandmother was involved somewhere, correct?
The review was trying to get my grandmother to say something, but she
Sir.
came in, man.
Sir, excuse me. Yes or no? Is that correct?
Just not understanding your questioning for this, man. I'm sorry.
There is also another matter that your grandmother was a named complaining witness or victim, correct?
Allegedly, man, but she came into your
So
court.
yes or no? That's all I need, sir. Yes or no?
I would say no. If she came to your court.
So, counsel, the court asked because there was something that involved your client's grandmother as an alleged victim, and I don't recall if that was assaultive or if that was a malicious destruction of property. I do not recall that off the top of my head, but I do recall that she was present.
If I said, I'm not sure because I wasn't there, but my understanding is, and the family is in court, that the grandma came and said that wasn't the case of the court, but I wasn't here. So it's my understanding, per the report of the family, the grandma is in support of his release.
Is the grandmother here?
She's not here, but the mother and sister are, and I spoke personally to his father, who is a retired Detroit police officer who was paralyzed and not in duty, and he's told me that he will ensure his son goes up to every Florida hearing.
Well, here's the concern of the court. Number one, your client is currently on probation here in this court. Secondly, this court is very familiar with your client, given the number of times that he's been charged in this matter with assaultive crimes. He has a prior domestic violence charge. And now here we are in this matter where your client is charged with assault with intent to do great bodily harm less than murder and domestic violence second offense notice. The court would also disagree that a tether would ensure the safety of the community, because that just means that we can locate your client if we need to locate him. A tether doesn't do anything regarding your client's potential actions or inactions or otherwise. So based upon all of those reasons, the court's going to continue bond and conditions as it is currently ordered. The court finds your client is a danger to the community and is going to continue the bond and conditions.
Judge, and would the court be inclined to refer it out for a bond recommendation report?
For DSU, I can certainly do that, but I can tell you all the times I've referred it, I don't ever get anything back from them here at this court, but I will certainly refer.
Thank you.
You're welcome. All right, we'll see everybody back next week on October 9th, and you witness and exhibit list by October 6th.
Yes, Judge, thank you.
Thank you. Have a good day. We are on the record in the matter of the city of Wyandotte for Shannon Pichet, 251419A, B and C. Mr. Golpa? We don't have Mr. Golpa. Just one moment. Okay, thank you. Oh, there he is. Okay. All right. And counsel, I'm calling okay. He's just grabbing his notes. It'll be just one moment. Who's Kim Gardner here on? Kim, oh, there she is, 10:30. Right, and counsel?
You're on the John Bogle, he seals from Friday, I'll be there. Oh, There's Piche.
Yes, I'm not sure if it's Pichet or Piche, but we'll find out in just one moment. Ma'am, your name for the record, please.
Janet Pichet.
Okay.
You are. Piche is charged with offering while intoxicated, possession of threat that having gold intoxicants. Like Miss Piche, at this point in time, she would wait a full reading of the charges, ask to plead not guilty, stand mute, ask to plead not guilty.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, schedule this matter for pretrial October 15th at 8:45 a.m. And counsel as to bond.
As the bond, Your Honor, Ms. Shea is 35 years old. She's single. She is gainfully employed as a housekeeping for Cornwall Health in Trenton. She has no prior criminal record. She's never failed to appear for any court appearances. As far as I can see, you check. We're asking for a person in this particular matter. If she gainfully employed, nothing. She's a lifelong resident of the city. Personal honor in this particular matter would be sufficient to make sure she is.
All right, ma'am. Who lives at the home with you?
I'm sorry?
Ma'am.
At the home with you.
Oh, my mom and my dad.
All right. Have you ever failed to appear in court for any reason?
Oh,
Are you out on bond in any other jurisdiction?
no.
If you were to test right now, what is in your system?
Alcohol and cocaine.
Given the nature of the charges, the concern this court has for the safety of both Ms. Bechet and the community, the court's going to order a $5,000 10% bond. In the event bond is posted, you are to report to probation, ma'am, to set up scheduled or random testing, not to possess or consume any alcohol or drugs unless prescribed. Thank you.
Thank you.
Sorry. I'm sorry. That's to count A. Count B and C will be 5,000 personal.
Thank you very much, Ron.
Thanks, Ally.
Okay, Mr. Shea. We'll see you in a couple of weeks. Make sure you're here in court. Thank you, Ron.
All right, and then we're going to call the matter of Robert Allen. City of Wyandotte versus Robert Allen, 241508A.
Good morning again, Your Honor. Robert Goldman, P1222, on behalf of myself and Robert Allen, present in the courtroom this morning. Mr. Allen, please state your full name for the record.
Robert Zane Downs.
Okay, and so counsel, you did approach the bench earlier to confirm one of the stated convictions that was showing for your client on the second amended pre-sentence report and recommendation. And then I did step off and spoke to Ms. Shaw, and that she then did confirm again, as somehow there was a misreading somewhere, that it was in fact dismissed.
Yes.
So now you did receive a copy of the third amended report, correct?
Correct, Your Honor.
Okay. Counsel, before we go into allocution or otherwise, Mr. Allen, let me state this, okay? That I understand that sometimes your emotions get the better of you, but my staff is not at all going to be somebody's verbal punching bag. It's my understanding that you were yelling and screaming so loudly at Ms. Shaw that she ended up hanging up on you, which she has this court's full support on. My staff is not to be verbally abused or assaulted. Is that clear? Thank you. Counsel, you may proceed. Did you have an opportunity to review the report and recommendation with your client?
Yes, Your Honor. And thanks to the court, your staff, and the probation department for the accommodation in verifying that one piece of information that we discussed at the bench bar. Fortunately, in light of that accommodation, there are no further additions, deletions, or corrections to be made. We are prepared to proceed with sentencing, having conceived and reviewed in full the third amended PSI report.
Okay. And counsel, as to the recommendations.
Thank you, Your Honor. With respect to the report, rationale, recommendation, and given my my time here working with Mr. Allen, as the court is aware, this matter, we've been before you several times over the last handful of months. And, you know, I think that actually provided a great benefit to me in allowing me to work even closer with Mr. Allen to understand him even deeper for purposes of today's sentencing. Your Honor, with respect to Mr. Allen, one of the things that I'm certainly very encouraged by is the relationships that he does maintain with his family, namely that being with his siblings, with his children, with his stepfather. Mr. Allen, while going through the day-to-day trials and tribulations given his physical condition.
Hold on one second. Counsel, just so you're aware, we can hear what you're saying in the microphone, and that's pulling from here. Okay. Thank you.
Your Honor, as I was saying that, and it's noted within this, the probation department's report, Mr. Allen has experienced a number of very significant injuries that have left him in a disabled condition, which he is unable to work in a full-time 9-to-5 sense of things, given, as I mentioned, the really significant injuries that he's maintained and really, tried to overcome over the last decade or so. But with respect to that, Your Honor, with respect to the time that he has, he certainly uses that to the most productive efforts with respect to taking care of his family. He provides a great caretaking service for his stepfather, particularly after the loss of his mother. He's a great father. He was just telling me about the overnight he got to have with his son due to a need for his son's mother couldn't care for her son last night. And we've oftentimes really spoke about the relationship that he has with his children, especially his youngest children now. And it's one of the most important things to him. And so I think he looks as a silver lining of his disabilities that gives him more time to be involved with his closest relationships. They not only provide a great productive use of his time, but they do certainly provide a great support system for him. They've been a great support system prior to this matter, and certainly during the course of this, as this has been challenging for Mr. Allen. But the challenge has also been a great source of understanding. This has been a very humbling experience for Mr. Allen. He has had to confront both his understanding of law and role in society, as well as a deeper understanding of himself. We have talked repeatedly, both with respect to concepts of candor to the court, candor to court staff, and particularly after reading the PSI report. He does understand he is certainly remorseful and regretful, and certainly is taking on efforts to address that, to be a more productive, responsible citizen member of the communities. Because that's all he does really want moving forward, Your Honor. He wants to understand that he did wrong, that he can make amends for that, and then go forward and live a productive, meaningful, and perhaps most significantly, quiet life. He wants to be able to take care of himself, his children, and his family at large. He wants to be a productive member of this community and any community that he may be in. And I do believe that with the deep understanding both of these proceedings as well as himself, he is capable moving forward in a very healthy, productive manner. I do think it is noteworthy if you do look at a prior record. His last offense of any kind was in 2013 for his driving while license suspended. He has not had any contact with the criminal justice system in the time since then on this matter. Or I'm sorry, Your Honor, he did have contact with the criminal justice system. Ultimately, it was a case that was dismissed. I should more clearly say he has not been convicted of any offense since 2013. If you further look at the record, his record does not have anything violent or assaultive. His record does not have anything substance related. His background is not one that contains history of substance abuse, substance use. And as we talked about his use of alcohol in the past, he has advised me that he does not really like to drink. When he does drink, it typically, as was in the case of this incident, occurred during a Lions game where he was watching with his son. And unfortunately, he now recognizes that there is a very necessary cutoff. People can enjoy the sporting events. Many people might like to partake with a beer or otherwise while enjoying that sporting event. But he understands even more clearly now that there are limits and we need to adhere to those limits so that we can be that productive, responsible member of the community. He's taken that lesson and every lesson gained through these proceedings, and he will channel that going forward to make sure if he ever wants to enjoy a Lions game like that again, that there's absolutely no use of an automobile at any time thereafter. His history does not provide one which shows a alcohol abuse problem. And I do believe that the difficult, challenging process of resolving this matter reinforced a very important lesson regarding responsible consumption. Your Honor, he is properly licensed with a medical marijuana card because that has been his primary form of treatment for the physical limitations or disabilities that he's had. He does not have a history of abusing or otherwise violating the law with respect to marijuana, and I believe has shown that he is capable of being a responsible user in that sense. But with respect to Mr. Allen moving forward, as I noted, he just wants to go forward, put this behind him, not because it doesn't matter or it's insignificant, but put this behind him so that he can be that best father to his young children, that he could be the best brother to his siblings, and the best stepson to his stepfather, especially at a very difficult time, having lost his mother and stepfather's wife. With respect to moving forward, Your Honor, the probation department is recommending a Senate fines and costs and alcohol titles. I believe that is an appropriate recommendation with respect to fines and costs, particularly in light of MCL 769.5. With respect to the alcohol tether, Your Honor, I'm not sure that that is necessary at this time. The reason I would say that is through the course of these proceedings, Mr. Allen has not violated the bond with respect to alcohol. Mr. Allen has not engaged in any criminal behavior involving alcohol or otherwise for that matter. And I'm not sure that an alcohol tether will necessarily provide a rehabilitative benefit consistent with sentencing guidelines in the state, but rather it would impose an additional financial constraint that I don't believe is tailored to a productive goal of sentencing. With all due respect, Your Honor, I would ask that the court follow the recommendation with respect to fines and costs. I would ask that the court consider not ordering the alcohol tether, given that there has been an alcohol issue since Mr. Allen was first arraigned in this matter.
All right, thank you. When did your client obtain his medical marijuana card?
Your Honor, the card was issued on May 7, 2025. However, I do know from speaking with Mr. Allen that the process was engaged in advance of the date of issuance because, as I believe we know, you have to go through doctors, submit the materials before it is issued. So I do know that he did generate those efforts prior to that issue date. And I would just further note, Your Honor, Mr. Allen did previously have a medical marijuana card. He had maintained one of the cards he had been issued previously. This was a card that was issued in 2012. This particular card expired in 2013, but Mr. Allen had advised me that he had continued to receive these cards up until the time that recreational marijuana was legalized in the state. And at that point, the cost of the medical marijuana card was outweighed by the ability to actually to obtain by way of the recreational legalization. And so when this matter arose, he did initiate those efforts to be properly licensed.
Okay. So let me ask a few questions. Did you receive that medical marijuana card as a recommendation from your treating physician?
No.
No. Do you have a treating physician?
No.
So you have continued medical problems for which you need marijuana for medication, correct?
Yes.
But you don't have a treating physician to treat you for those continuing medical problems.
No, because when you go to the doctors, all you try to do is give you pills for your pain. And I don't want to be addicted
Sir?
to pills.
Sir,
Well,
as the patient, you definitely have a right to engage in conversation with your treating physician as to the best course of medication treatment for you.
Okay.
The concern this court has is that you have alleged that there is a number of medical conditions by which you need marijuana. But this court is very much aware that when an individual walks into a medical marijuana clinic to obtain medical marijuana card, there isn't any follow-up to confirm that that medication is in fact working as it should, such as somebody with high blood pressure has follow-up appointments with their doctor to make sure the medication is working. Somebody with high cholesterol or sugar issues. So if the marijuana is for true medicinal purposes, then there should be requirements and I'm sorry, not requirements, but follow-up appointments that are already scheduled and that you see on a regular basis to ensure the medication as prescribed is working for you. That is this court's requirement as it relates to marijuana for medical purposes, which I know I've stated to you before. And so you have this medical marijuana card that you obtained while on bond and under jurisdiction of this court without having anything from your treating physician. And further, just so you're aware, all I would need from your treating physician is some communication that that's the preferred method of medication, and you wouldn't have to even go through the steps of the medical marijuana card. And I know I've stated that to you before as well. Which apparently is where things went awry with the conversation with Ms. Shaw. Council, after review of the report and recommendation, hearing from council, hearing from Mr. Allen, the court agreed that there is not reasonable grounds to depart from MCL 769.5. The court, in further review of the report regarding the report of substance abuse assessment, shows your client is a category 3 alcohol and 4 drug user. Presumably, the category 4 is based upon your client's marijuana use. Based upon that, the court does find that the recommendation is appropriate. The court's going to order 60 days on the alcohol tether. So what I'm going to do is I'm going to have you, I believe that the Wayne County Jail, I guess it depends on who answers the phone when, or responds to the email. You can go to Wayne County Jail for that. Not in custody. You just go down to the Wayne County Jail and then they can affix you with an alcohol tether. That's much more cost effective than an independent third party. The court's going to also order a $300 fine, $100 screening assessment fee, $300 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $825. And sir, do you have any, I think you posted a bond. You did post a bond.
Yes, Your Honor. It was just going to ask if we could confirm Mr. $500 bond, if that could be applied to the fines and costs in this matter.
You did.
Mr. Allen just indicated to me that you could pay the balance. Yes.
You have $325 to pay today. Okay. Then yes. So then I will indicate that's payable today. All right. So you're going to go over to probation. And they are going to give you the information regarding going to obtain the alcohol tether.
Okay.
Okay.
Yes.
I strongly hope that you've heeded what I've stated earlier and that you've listened to your attorney with his excellent representation of you, sir, in what he stated that you've taken away from all of this. So, and I'm hoping that you are not going to verbally assault my staff as you are going back there to get information regarding your alcohol tether. Okay. Thank you. Have a good day. Good luck to you.
Edward Dante Morales, Chief OP 1384098, 21F235822.
Attorney Mike Baldwin on both cases for Mr. Morales, who is in custody on.
Mr. Morales, your name? You have to unmute there, sir.
Get the deputy.
I got it. Okay.
Your name?
The host. Am I unmuted now?
I need your full name.
Edward Dante Morales, Your Honor.
All right, you're going to plead guilty, this says, to the charge of resisting obstructing an officer on file 5822 on the basis that you gave a false name. True?
Yes, Your Honor.
That is a misdemeanor punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, Your Honor.
Again, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to trial by court or jury. You have the right at a trial to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. And if you're guilty, you'll be giving up all those rights, and we're not going to have a trial of any kind. You understand that?
Yes, Your Honor.
All right. To the charge, resisting, obstructing officer, how do you plead?
I plead guilty, Your Honor.
I can't hear you, sir.
I gave my false name because at the time, Your Honor,
Sir,
I plead guilty, Your Honor.
listen to me. Do you plead guilty or not guilty?
I pled not guilty, Your Honor. I mean, no, I'm sorry. I pled guilty, Your Honor. I can't, it's kind of hard to,
I'm going to ask you again. To the charge of resisting, obstructing officer, how do you plead?
guilty, Your Honor.
Were you in Flat Rock at 26813 Telegraph on May 21 of 21?
Yes, Your Honor.
Did you give the police a name other than your own name of Edward Dante Morales?
Yes, Your Honor.
And did you give them a different date of birth?
Yes, Your Honor.
Are you on probation or parole?
Right now, I'm on parole, Your Honor, but I'm almost off.
Were you on parole on May 21 of 21?
Yes, I was, Your Honor.
You understand by pleading guilty to this charge, this would be deemed a violation of that probation or parole? It could be revoked. Listen to me, please.
Yes,
it could be revoked and you could be incarcerated as a result of this plea and conviction. Do you understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Plea is accepted. Now we have a sentencing.
No report.
I know. What is he in custody at?
Just, I'm looking at the register of actions. It looks like he got picked up. I think he was arraigned back in May of 21 on the initial concealed stolen property. And I think I don't know how he got picked up, but I'm looking at the register of actions on the.
I know he's got these two. He's got 10,000, 10% on each one. I just want to know if he's got other holds.
I didn't inquire as to stolen.
Can you tell me, sir, are you in custody just on these two?
No, Your Honor, I got a charge that happened in August of 2022 that they just pulled it up just now. So
listen to what I'm asking you.
He's trying to develop credit, and that's where we've had some confusion.
Develop credit?
Time credit in being in.
I didn't ask you that.
No, that's not what I'm saying, Your Honor. I said I'm right now in custody for a charge that happened in August of 2022. Right now, it hasn't even been adjudicated. There's been not even a preliminary examination yet.
Oh,
so
all right.
And I was given a PR bond for this charge right here. And
which charge? Which
charge I'm in here for? Right, but I'm not the charge with you, but for the charge for which on this one here, which is a felony, I was given a PR bond.
All right, so you're just awaiting sentencing.
Yes,
for your case, I am.
I got it.
And I think I saw PR in that one of those register of actions, but maybe that was historical. And then it compounded because he wasn't shown. He was arraigned on September 30th of.
Boy, you are really going out of your way to be unhappy here. You know that? Was there a police report in this file?
There was.
I'm talking about in the one for the concealing stolen property.
I didn't see a report in the file for that. That's in 2020.
I know.
I didn't see a report. And you're just for edification, it was a sentencing today, so I didn't delve into deep as to the facts of the case.
Well, I get it. I'd like to be able to sentence him, but I don't.
You don't have a screening and assessment.
I don't have a pre-sentence report. He didn't show up for that. The case been going on for 4 years. Yes, sir.
Your Honor, if I may, I know that when the case occurred, I was incarcerated. Yeah, I got arrested, got incarcerated. I did time at the Wayne County Jail. I remember being released from there. I did like 4 months or more in there. My parole, that's why there's no parole hold on me for that charge right now. Because I've done time for the parole and for I had a piece of paper when I left the county jail.
Slow down.
Okay.
You got a 4,010% bond that I set. I released you I set a bond of 5,010% in December of 20. You were in custody for 5 days. You came back in front of me. I gave you a PR bond. On April 28 of 21, I set a 4,010% bond when you had a warrant out and came in front of me. 7 days later, I gave you a PR bond. And then you just didn't bother showing up.
Your Honor, it's not that. Please, I know it's so hard to believe, but please understand, it's not disrespect to this court. That's not this what this is about. I know I was locked up for a long time because the girl that was with me when I got arrested.
Not on this case.
No, on this case right here, I got the time because she picked me up and I got out of jail with the piece of paper with this case from Wayne County Jail.
You were in custody for 5 or 6 days from December 11th to the 16th of 20. You were in custody on April 28th when I set a bond 4,010% until May the 5th. You've been in custody since Judge Kirsten set the bond of 10,010% the other day.
September 30th.
September 30. So I'm not saying you don't have some credit for time served.
And that's what I explained that he does.
I understand.
Hold on, Morales. Hold on. He says he had a judgment of sentence adjudicating the case on concealed. I checked the register.
There isn't.
It's the rest. It's blank.
You have gotten yourself in all kinds of trouble because you don't show up.
No, I'm not disputing that.
You what?
I said I'm not disputing what you just said. I'm not disputing your Honor.
You should have never, ever had to serve this kind of time on this case. Although I don't know much about you because you didn't bother showing up for your pre-sentence report. And if I let you go, you know what's going to happen? You're not showing up again.
Your Honor, that's not. I don't believe that, but Your Honor, I've been working at Home Depot. I've been working at Smokers Depot on Liberty, Michigan. I can give you the phone number to my boss, and I've been working at Harry's Pizzeria, 2 places for the past 3 years. I haven't missed one day in 3 years, and I haven't had one police contact, not a civil infraction, nothing to do with law enforcement in 3 years, Your Honor. To me, that's fairly good for a guy like me that has a record like I do. I don't have not one police contact, Your Honor, in 3 years.
I'm just pulling out your record here. Let me take a good look at your record.
In over 3 years, I haven't had nothing, Your Honor.
Right, but you've been a criminal for 35 years.
Thank you, Your Honor. That's why I'm saying that's pretty good for a guy like me that's had a record like I did, and I've done good for the past 2 years. All I do, I'm not drink. I don't use drugs. All I do is I work. Every day I get up, I go to work. That's what I look forward to.
All right, okay, settle down.
Well, I just miss it. I'm just like, it's a good thing, Your Honor. People like me you don't experience that in your life.
I'm having a hard time understanding you. Just slow down and keep your voice up. Would you please do that for me?
Yes, Your Honor.
And you got quite a history here.
I understand. I know, Your Honor.
And nobody's going to think that you were a choir boy. You know what I'm saying?
Absolutely.
All right. So just let's get past this. If I knew that they recovered the property, that'd be a different thing.
They did, Your Honor. They got the property. It was in the car when I got arrested, Your Honor. It was just a lawnmower. That's on God's word. That's all it was. It was a lawnmower, and they got the property. I had originalized it, Your Honor. They recovered it. They gave it back to me.
Settle down. Settle down.
Thank you, Your Honor.
Yeah.
Let me take a look at this. So you've spent some time in jail here because you did not bother showing up is the problem. But stop. I'm telling you to stop. Just don't interrupt me again. You got a warrant out of Dearborn, by the way, that you've had since 2021.
Yeah.
I think right on your funds and costs. I can't find that stuff now. No objection, fines costs. Is that what he said? No objection, finding costs, sentence to run concurrent.
With the existing injury, correct. So whatever jail credit he has, it sounds like he might have 3 small chunks.
Thank you. I got it. I need to talk to you before you leave about something completely unrelated to this, okay?
Yes, sir.
$14. Well, he's right. He hasn't been in a lot of trouble lately. All right, Mr. Baldwin, let's do an immediate sentencing. I can kind of read between the lines here. They caught him with the lawnmower. He says they recovered it. They didn't leave it in the trunk if they knew it was stolen property. So I can believe that. What do you want to tell me before I sentence?
I'm asking that the court sentence my client all cases to a time served with jail credit to run concurrent. My client has already given a brief background history, recent history of what he is doing with his life. Apparently, he is within the last 2 years has been a lot unproductive.
I know, but the problem is he's almost, what are you, 60? Looks like you're going to be 61 here shortly, right?
Yes, ma'am.
Aren't you getting tired of doing this?
No, that's why I haven't done nothing wrong in 3 years.
All right, good. Anything else you want to tell me?
Well, whatever you do, I thank you for your time. And I'm sorry that I cost us court time, Your Honor. I really am.
Sorry that he what?
I apologize for the time I cost us court.
Don't worry about my time. That's what I
And
do.
to take something from somebody, Your Honor, I appreciate things a lot more when I buy it and
All
earn it.
right, good enough, good enough. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment. 4 1/4, 17 days on both cases, credit 17. We'll close those cases out, Lisa. Send something over and have them released in terms of these cases, if you would, please. Thank you very much. Have a good day, sir. Good luck.
Thank you, Judge.
You're welcome.
Thank you.
So-
Attorney,
Joseph Adam Broski, 219F231964.
The record, House Counsel, my call
Sir, your name?
Joseph Roscoe.
He was arraigned the other day. I set a bond because he'd ignored us for 6 years. He's going to plead guilty to no ops. They're going to dismiss the suspect. True?
Yes.
Is that what you want to do?
Yes.
If you plead guilty, the possible penalties are up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
You can sign, read, and understand the advice of rights.
Yes.
If you plead guilty at any time, you'll be giving up all those rights and there will not be a trial. Do you understand that? For the charge, no valid operator's license on person, how do you plead? Reoperating a motor vehicle in the city of Flat Rock, county of Wayne on November 9 of 19 at 2:10 in the morning on Gibraltar near Cahill.
I believe so.
Did you have a valid operator's license on your person? Sir?
No.
Are you on probation or parole?
Yes.
Were you on probation or parole in November of 19? No. Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No.
I'm going to accept your plea to no ops, dismiss the suspend. He's homeless. He's not working, right?
Oh, right. Yes.
He has an expired license as of September of this year. So we're hoping to keep that license.
You've been in custody since what day? The
29th.
What day was he taken into custody? Why would you do this? Why would you do this? This is crazy. Look,
This was never just.
seriously, listen to me. You got to get your life in order. Did you graduate?
Yes.
Why aren't you working?
I got fired and
Right. Remind me. Why'd you get fired?
just productivity and stuff, like
Probably not showing up, right?
here or there, yes.
He's been in custody since what day did you say?
Saturday.
Saturday was the 27th.
I think you had 6.
You don't have any children or anything, right?
No.
Do you want to say anything? 100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 275 or 6 days credit 6. Please get your life in order. You're 25. You got 65 years ahead of you. But you can't be homeless, not working, and avoiding courts. Good luck. You'll be released if you have no other holds. Thank you. There's no reason for you to be in jail. None.
Mike, you got a second? Oh, absolutely. For you, I got a minute.
All right, we're back for our afternoon docket. It's 1:59. We expect the prosecutor will be here momentarily. Mr. Truckee is here. His client is here. Ms. Furlow, would you come over here and have a seat, please? The lyric today was, there is a young cowboy who lives on the range. His horse and his cattle are his only companions. Mr. George doesn't know it, but Mr. Truckee does. Mr. Truckee, have you been in discussion with the prosecutor on these matters?
Yes, Your Honor.
All right, some are ordinance and some are state statute. Mr. George is also here on behalf of the ordinance cases. I tried to put these in chronological order.
We have a resolution on Mr. George's file.
All right. Which prosecutor have you been working with?
Ms. Camfield.
All right, very good.
In fact, I was just with her.
I'm sure she'll be here in just a minute. This is the only pretrial we have this afternoon, and involves 8 separate cases, but we have just one defendant. So our whole lot of time we can spend on your cases. I guess we can start to just detail everything that's scheduled for today. As I said, some are ordinance cases, some are state statute cases, and they all involve Cinquez Marie Furlow. That's you?
Yes.
All right. The first case in time is a state statute, 24881. It alleges that on April 16th of 2024, you drove a vehicle without security. You failed to stop at the scene of a property damage accident. You had open intoxicants in a vehicle. You had no valid operator's license. Sometimes it got charged as no ops. Sometimes it got charged as driving suspended, but this is charged as no ops and charged with unlawful use of a license plate. Most serious of those charges is the no insurance, which carries a penalty of up to a year in jail and a fine of not less than $200, not more than $500. That's April of 2024. The next count is May of 2024. May 23rd of 2024, and file 24911 SM, and I think 92. In that case, the defendant is charged with no insurance under the insurance code and driving suspended second offense. Those are both misdemeanors punishable by up to a year in jail. This happened allegedly in the village of Constantine. Because they're punishable by up to a year in jail, they're on the state statute. Defendant was on probation at that time and filed 211797, an earlier case. Said she wasn't supposed to commit any crimes. Then on June 1st of 2024, she got another ticket in Three Rivers, and this is the Three Rivers case, 24964OT. They didn't charge driving suspended. They charged with no valid operator's license ever, no valid ops. Punishable by up to 90 days in jail, a fine of up to $100, 2 points. They didn't charge no insurance. They charged no proof of insurance. So they kind of watered down both of those charges. So we're still in 24. These files are replete with her failing to appear when she's supposed to, which is part of why the cases are so old. Next, This occurred allegedly December 2nd of 2024 in the village of Centerville. That is file 25358SM. That alleges a retail fraud in the third degree at the Shell gas station, which was food. They charged that as a retail fraud third, which is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Then we get into 2025. In February of 2025, Ms. Furlow was charged with 2 counts of domestic violence on Skylar Ballard, a former resident of her household in Centerville, and an assault and battery on Mr. Craig Kloppenstein. Those are all misdemeanors punishable by up to 93 days in jail and a fine of up to $500. Then in file 251764, she's charged alleging that on May 2nd of 2025, that she stole $682 worth of stuff from the Walmart store in Three Rivers. That's charged as retail fraud, second degree. Then June 1st of 2025, it's alleged that she ran into Paul's Pantry store in Three Rivers and stole several expensive bottles of liquor. And that is also a retail fraud, second degree, punishable by up to a year in jail and a fine of up to $2,000. And some of these, there's a video, alleged to be a video. There is in that one. There is in the Walmart one. I don't know about the others. So one of these is under Three Rivers ordinance. Everything else is under state statute. Angelique Camfield is here, and she's inherited some of these. They happened before she joined the office. As I indicated, there have been a number of missed hearings and bench warrants and that sort of thing, but I think we finally at least got on track to get everything here. Miss Sinquet's Furlow also had some health issues which caused things to be adjourned. So I set all 8 of her cases for pretrial today. Mr. Truckee has all of them. In fact, we were here on an earlier one and some of the new charges have come out. So I think we got everything. Ms. Camfield, are you aware of anything else that's pending against the defendant?
I don't believe so, Your Honor. I have 6 of the files and I made a package offer. I did speak with Mr. Truckee earlier today as well as yesterday, and I think it'll be partially accepted. And then a couple matters may be set for trial.
All right. What's the prosecutor's offer on these matters?
I'm getting into my system now, which is giving me fits and starts in the moment.
I'd also have to inquire about file number 7. Ms. Campfield indicates she's got 6.
I thought I had, let me
I
count.
have 8.
Yeah, 1, 2, 3, 4, 5, 6, 7, 8. Only one of them is ordinance.
Okay. Well,
I just recited them while I was waiting for you to get here. Maybe I should have waited.
I was on a call. I don't know. I don't show anything pending in review.
All right, well, let's hear what your offer is, then we'll
Okay.
parse out what cases we have.
All right. So the offer was to plead guilty to 1 count of domestic violence and 25 to 59 DM, dismiss the remaining counts. Plead guilty to retail fraud second degree and 251406, dismiss 25358 and 24911. I would request restitution on all of those, however. Plead guilty to leaving the scene of a property damage accident and open intoxicants, and no license, dismiss improper plate, and no security. I'm going to refrain from the recommendation because of the juvenile present in the courtroom.
Yes, I'm not thrilled about that.
Can I say something?
Yes.
I had to bring her. We leave her in the hospital. She got hands, mouth, and feet, so I didn't have to.
Oh boy.
Yeah, she didn't have a baby.
Wow, want her in here?
No, I didn't.
Mr. George has suffered through hand, mouth, and
Yeah, I've
feet.
never heard of it until she started going.
She's
to school.
got it right now?
Yes.
Oh my gosh.
Yes. I had to bring her. She can't go to school. She's in school. That's where she got it from.
Mr. George, what's your offer?
Your Honor, we would offer that if she were to plead to no valid operator's license, we would dismiss the civil infraction.
I'm going to adjourn this. This is a highly contagious disease that's very debilitating. The adults that I know that have recently had it had very terrible and serious consequences. She shouldn't be in here.
Yeah.
So as much as I'd like to resolve this today, I'm going to call the maintenance department and have them come spray this room down. We're going to reschedule this, and you're not to bring any children with you when you come. You'll have time to discuss the plea offer.
Okay.
Gee whiz. Ross, are you here on October 16th? Okay.
Yeah, did my mom call you and tell you about that? After I came to court from Middleton, Officer Britton had followed me while I was walking home to her house.
Talk about this.
Okay. Oh, yeah, he was talking about the 16th.
You're not on the 16th. You're here. Are you here on the 9th?
I'll tell you something.
I'm not.
Are you
I got
available?
a 1:30 with Judge Kane on the 9th.
All right. How are you available on the 16th?
It looks like I could be here 1 or 2.
All right. Let's continue this to 2:30 on October 16th. Ms. Furlow, there's a substantial chance that you're going to jail.
Okay.
These are a bunch of cases: thefts, assaults, driving. You got a bunch of thefts, assault, and driving convictions. You have at least 2 assault convictions, 4 or 5 retail frauds. You never show up. Sometimes it's medical, sometimes it's neglect. And so I don't want you to bring any children with you, and I don't want you to bring any children that have a communicable disease. So we're going to adjourn this matter. I don't wish to even be in the same room with a child that has this infection. So I really would like to finish this today, but I don't want all of us to get hand, foot, and mouth disease. So you're free to go. We're going to pick this up at 2:30, 2 weeks from today.
Okay.
Mr. George, you may be here anyway, but if you're not, I'm not going to require that you be here.
I already have some scheduled for that.
All right, thank you. We'll be in recess. I really had hoped to finish this today, but I don't want to be in here.
All right, the court is calling 2024 CR 011954, State versus Dora Marie Bravo. Can I have parties announce?
Daniel Cranbrook for the defense.
And are you Dora Marie Bravo?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? You're going to need to speak up.
Yes, ma'am.
Are you the same Dora Marie Bravo who was placed on deferred adjudication in 2024 CR 011954 for the offense of possession of a controlled substance penalty group 2, less than 1 gram, on June 3rd, 2025 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Filing condition number 14AA, on or about the 11th day of August 2025 in Bexar County, Texas, the defendant Dora Marie Bravo did then and there fail to comply with the rules, regulations, or instructions of the Bexar County Community Supervision and Corrections Department, in that the defendant failed to follow top recommendations for SATIF in violation of condition number 14.
How do you plead to that? True or not true? Did you understand by pleading true to violation 14AA, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of 14AA?
Yes, ma'am.
Court will find 14AA true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion, enter an adjudication of guilt and sentence to 126 days in the state jail facility under 12th Degree.
Would it be in the Bexar County Jail? The 12th
Yes, state jail facility, Bexar County Jail.
Those are.
I'm
Oh,
sorry,
just 1 second.
Bexar County Jail, Your Honor.
No problem.
Apologies.
No problem. All right, here's my question. What has she done on probation?
She never came out of custody, Your Honor. So she took the plea back in June, and they recommended SATIF, which she didn't agree to.
Okay.
So she's been in custody for the whole time.
All right, so I'm not going to follow this agreement. There are rules and regulations that you have to follow for probation. Otherwise, you're not on probation. You're just doing your thing and telling people what you would not do. Your conditions of probation were parenting classes, which tells me.
I signed up for parenting while I'm
No. So here's the thing. You were supposed to be going to SATIF because obviously you have a drug or alcohol problem. If you did not, they would not have recommended that. So I'm sorry, what?
It wasn't on the paperwork that it was given to me.
No, they told you that you're supposed to be going to SATIF.
She's saying for your evaluation, not for your original.
Because according to the conditions that I gave you, I said that you are not to have any contact with Roberto Avalos, JCPenney stores, and that you're to complete the TAP evaluation while in custody, follow TAP recommendations. There was a referral to felony drug court, and you decided you don't want to do that. And now you feel as though you're entitled to an agreement where you just do Bexar County jail time. It's not going to happen because you didn't follow the conditions that the court set for you.
If I may, Your Honor?
Yes.
She doesn't have any felony convictions at this time. She was willing to take the conviction in order to not waste anybody's time. She just doesn't think so that she'll be successful on the probation. And so she's asking for the full plea.
All right. Well, what I can tell you, part of my issue is, not issues, part of my duties is to protecting the community. And for me to say that you were to do parenting classes, that means that you have a child. Otherwise, I wouldn't have recommended parenting classes.
She doesn't have custody of him at this time.
Yeah, see, that's the problem. The at this time part, that's the problem. So what would end up happening is you would go to jail, you would do your 124 days or whatever it is. The jail would give you 3 for 1, and you probably have a judgment satisfied, or they give you 2 for 1. You probably have a judgment satisfied. You would walk out, go do your drugs or whatever, and then go pick up your child from wherever he is. So these are your 2 choices, and these are your only choices. Either you're going into inpatient treatment, or either you're getting 2 years at the state jail facility. Which do you prefer? All right. So the court will deny the motion, alter and amend conditions to include SATIF And upon release from SATF, there's to be no unsupervised contact with or residing with minors. And that will be revisited once she completes her parenting classes. In probation, was she not eligible for felony drug court?
No, that's not. Oh, let me just double. Did not meet the criteria, Judge.
All right. All right. Is there anything else you need from the court? All right. Thank you. Thank you. Thank you, Judge. And she's to remain in custody until transfer to SATF.
Where do you want?
All right, court is calling 2024 CR 008085, State versus Dean Delgado. Could I have parties announced?
Ron Zimmerman for Mr. Delgado.
Are you Mr. Delgado? Counsel, have you received all discovery? Did you review it with your client?
I believe so, and yes, I have.
Court will find that the state is in compliance with discovery. Mr. Delgado, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No objection, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? And count 2, you're charged with theft, $2,500 to $30,000 of a vehicle. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Delgado, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you are not a U.S. citizen, by entering this plea, you will be deported, not allowed to re-enter the United States, and be denied naturalization. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a $2,000 fine, 15 months in the state jail facility. This will run concurrent with 2022 CR 3996. State is proceeding on count 2 only. There are no applications. Did you understand that to be your plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, have there been any such motions?
No, Your Honor.
Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
No objection, Your Honor.
Did you review the admonishments and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and stipulated to stipulations of testimony. Court will accept into evidence states exhibits 1 and attachments and review the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Delgado, he is young and he does understand the difficulty that he has placed himself and his family in. And he's willing to accept responsibility for his actions. And he would request that the court go ahead and observe and grant the plea bargain.
All right, the court will follow your agreement, sentence you to a $2,000 fine, 15 months in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 3996. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. And cause number 2022 CR 3996. Are the file stamp dates you all have for the motions to revoke, were these filed on April 25th, 2024 and March 2nd, 2023? All right, thank you. All right, in that cause number, did you review the motion to enter adjudication of guilt and revokes community supervision? And also the first amended motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it? All right, are you the same Dean Pablo Delgado who was placed on deferred adjudication in 2022 CR 3996 for the offense of unauthorized use of a vehicle on October 5th, 2022 for a period of 2 years? Is that you? All right, state.
Violation of condition number 1 on or about 4th day of July 2020 in Bear County, Texas. The defendant, Dean Pablo Delgado, committed the offense of theft. Violation.
How do you plead to that? True or not true?
True.
And then violation of condition number 4 in Bear County, Texas. The defendant, Dean Pablo Delgado, did then and there fail to report to the supervision officer as directed for the months of March, April, May, June, July, August, September, October, November, and December of 2023, and January, February, and March of 2024 in violation of conditions.
All right, how do you plead to that? True or not true? Any
No.
objections?
No objection, Your Honor.
Did you understand by pleading true to violations 1 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violations 1 and 4? Court will find 1 and 4 true. Is there a proposed agreement? All right, what have you done since you're on probation other than pick up new offenses? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand, state your name for the record.
Dean Delgado.
All right, what have you done other than pick up new cases?
Well, I've been working with my uncle. He's a contractor and stuff.
Well, have you been working with your uncle? And because you just pled to another vehicle offense.
This was after the fact. So after that, I've been done with that. I realized what I did was wrong, and I'm ready to pay for what I did. So after that, I've been working with my.
All right, so I can tell you for this, I'm not going to give you 15 months because you haven't done anything. The only thing you've done is pick up new cases, and it appears that you barely reported. So you haven't done anything. I gave you a curfew. Obviously, you violated your curfew. You haven't been reporting. You just picked up a new case. So the court is going to find you guilty or revoke. This will run concurrent with 2024 CR 008085. Court will sentence you to 2 years in the state jail facility. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Good luck to you.
Thank you, Your Honor.
Thank you. All right. Then let's bring up Lynn Morin. And counsel, let me ask you, are you all able to come back on this for tomorrow? Is that possible?
I've got a federal court sentencing at 10, but I can come here after that.
Okay. And the only reason why I say that is because it's well past 12. And I know the staff is going to need a lunch break. Court reporter is going to need a lunch break. And then we start up jury trial. Or if you want, we can do it between a break in our trial. So if the state and defense, state, do you have any witnesses? Okay.
I've got 2 witnesses. I don't think the whole thing will take longer than 20 minutes, but.
Okay, just 1 second. Lunch has been ordered for the staff. Let me see if it's arrived. To get their break.
Yes, Your Honor.
All right, court is calling 2025 CR 001248, State versus Lynn Wayne Morin. Could I have parties announced?
Mantle Brown, State.
Louis Martinez on behalf of Mr. Morin.
All right, and are you Mr. Morin?
Yes, ma'am. Yes, Your Honor.
All right, you entered a plea of guilty on July 21st, 2025. We were awaiting the PSI report. According to your plea bargain agreement, punishment is to be assessed at a cap of 30 years. There's a $5,000 fine and there are no applications. And there's to be Chapter 62 compliance. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
Yes, Judge.
Any objections, state or defense?
No objection, Judge.
Not to the PSI, Judge.
All right. And the court is in receipt of documentation tendered to the court by the defense attorney. And it appears to be letters from therapists and from other parties.
Correct, Judge.
All right. The court has reviewed those. State, have you had a chance to review those?
Yes.
All right. State, any witnesses?
No witness, Judge.
Defense, any witnesses?
Yes, Judge. I've got 2 witnesses. The first would be Hugh Morin, Mr. Morin's brother.
All right. If you'll step to the side, sir.
They're back against the counter.
All right. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand if you'll state your name for the record.
Hugh Morin.
All right. Defense, you may proceed.
Hugh, you're Lynn's brother, correct?
That's correct.
And how old are you, Hugh?
I'm 60.
And how old is Lynn?
69.
Now, do you understand what your brother's charged with?
Yes, indeed.
And you understand that the plea bargain in this case calls for the judge to decide a punishment between 15 years and 30 years.
That's correct.
And so, obviously, what you're asking the court to do is consider something closer to the 15 years than the 30.
That's correct.
What kind of did you have any indications that your brother had gotten involved in this stuff?
I had no idea at all.
Yeah. Before his arrest?
No, I had no idea.
Are you telling the court that your brother didn't do this? Are you saying that this is not?
I just didn't know anything about it.
Okay.
But prior to the arrest, I had no idea.
But in speaking with your brother, he's taking accountability for it, right?
That's correct. Yes.
Has he tried to blame anybody else? Do you guys?
No.
Has he minimized it or somehow said, "Hey, look, you know what? This is just a big mistake"?
No, not at all. he's taking full credit for what he's done.
Okay. And so, I mean, this is a very troubling case, right?
Yes.
And you understand that there are real victims when it comes to this material.
As far as I know, I'm not real familiar with it, but
No, what I'm saying is, I mean, these aren't generated images. I mean, that there are children that get photographed.
Right.
So no one's minimizing that.
That's correct.
Prior to your brother's arrest here, what kind of a reputation did he have?
Was hardworking. He's worked in the medical field for 30 something years, and has great friends and been an uncle to my son and everything, and had good interactions with him and stuff like that.
How many grandchildren are in your family?
I only have one son, and he's 30.
And there were never any indications that that Lynn might be doing anything appropriate with the children family?
No.
Okay, whether
we have a real small family. I mean, it's down to just me, Lynn, my son now at that point.
But no rumors or whispers in the extended family that anything improper had ever happened?
No clue, no idea. Hadn't heard anything like that at all.
And so when he got charged with this was just a complete and total shock.
It was a complete total shock to me. Yes, that's correct.
Because this really is not consistent at all with the Lynn that you've known for your life.
That is correct. Yes, sir.
And so in talking to your brother, you said your brother took responsibility, right?
Mm-hmm. Yes.
And he made it known to you that he's been hiding this part of his life from everybody else.
Yes.
Now, you said your brother worked in the medical field.
That's correct.
What kind of work was he doing?
He's a speech pathologist.
Okay. And he worked with both adults and children.
That's correct.
Okay. And were you aware of any kind of complaints or any reports of impropriety?
He'd had a clean record. Worked there forever. No problems, no write-ups or anything.
Okay. And the pre-sentence report in this case indicates that he doesn't have a criminal history. Is that consistent?
That's correct. Yes. He's never been in trouble at all.
Okay. And your brother's 69 years old.
Mm-hmm.
And how is his health? Let me ask you.
I know he has diabetes, a little bit of asthma, and he's got arthritis.
Okay. So, I mean, health issues that are consistent with a man his age.
Right. Correct. That's correct.
And now what you're asking, understand that if the court were to give something closer to the 30-year sentence, at your brother's age, he's likely not.
That's correct.
Yeah. And so despite these, the troubling nature of the accusations and the activity, you're asking the court to give him something closer to the minimum, something that would allow him at least some life expectancy when he gets out.
That's correct.
Now, I talked about the plea bargain that was a cap of 15 years, essentially anything between, cap of 30 years, anything between 15 and 30 years. Okay. Is there anything unfair about that range of punishment?
I'm not real familiar with this, but I would feel that, the fact that he's never been in trouble before, that they could possibly give him closer to 15.
Okay.
Yes.
So what I'm saying is, given the nature of the activity, it's not unfair to see him going and doing prison time, right?
Right.
Okay. I mean, you're not happy about that.
No.
You wish there were another way.
Sure.
But you understand that him being punished this way is fair and it's appropriate.
That's correct. Yes.
I'll pass witness.
Any questions? All right. Thank you so much for coming in. All right. Call your next witness.
Lynn Warren.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Good.
All right. You can lower your hand, state your name for the record.
Wayne Moore.
All right. You may proceed, counsel.
Lynn, in looking at the PSI, it looks like you never had any criminal history. Is that correct?
That's correct.
Okay. And so the first time you wind up in court is for something serious like this.
Yes, sir.
I'm looking at the PSI, and it looks like you acknowledged guilt in this case.
I did. I am guilty.
And have you ever denied, since the time of the arrest, have you denied to me or anybody else that you were guilty?
No.
Yeah. Lynn, if you're a man of your age with no criminal history, how did you get yourself involved with this material?
I became addicted first to pornography, and it led to me going to more, as I chased what they call dopamine, something I've learned in my 12-step programs.
Okay.
I started doing more edgier and edgier stuff until I crossed the line.
Mhm.
And I just, once I did that, I got hooked on a very perverse medium, but it was the medium I was addicted to.
Right. So there was some testimony. You worked as a speech pathologist.
That's correct.
And did you work with both adults and children?
I did.
Did you ever do anything inappropriate with any of those children?
I did not.
Did you ever do anything inappropriate with any of those adults?
No, I took care of them. I did nothing inappropriate with either one.
Okay. Never any complaints, or you were never fired from one of those jobs for anything inappropriate? Okay. So even though you were dealing with these addiction issues, thankfully it didn't spill out into the physical world.
That's correct.
Yeah. Since the arrest, have you taken any measures to deal with your addiction?
I have. I've joined a 12-step program that's called SPAS, Sex and Porn Addicts Anonymous.
Okay. And so there are 12-step programs for those sorts of addictions.
There are.
Okay. And are they, I'm not going to ask for anyone's identity, obviously, but are they sparsely attended, or are there actually significant amounts of people that are in them?
They sometimes have as many as over 70 people. They do a Zoom meeting.
Okay.
And the one I go to is on the West Coast.
Okay.
And it has a very good attendance. And, it helps us to kind of deal with the, just like the AA 12-step model. They lead us through how to find relief, or, to be able to
live without this.
To learn how to manage it and not let it rule my life.
Okay. And so in doing so, in these 12-step programs, they refer to staying away from these things as sobriety, correct?
Yes.
Okay. Just like we talk about with drug and alcohol issues of sobriety there.
Yes.
Okay. And to this point, how many days have you been sober?
I have well over 400 days of sobriety since I joined the SPA group. I had one relapse, and that was that violated their no self-love, no masturbation.
Okay. And then, so do you journal as part of that 12-step program?
I do, just to log it and to help keep me aware of how much sobriety I've obtained.
Okay. And to date, how many days have you been able to log?
It's over 400. 403 as of yesterday.
Judge, I'm going to tender to the court, not for the reading of it, but just to substantiate that he's logged in.
Yes.
His journal that has 403 entries. So we're not asking I've checked with the state, we're not asking the court to read it, just to confirm he's done that. In addition to that 12-step program, have you seen a counselor?
I have.
Okay. And did we get a letter from that counselor?
Yes, I believe it was in the packet that I gave you, or that you gave to court.
And that's what we tendered over to the court for the court to
I believe it was, yes. So
in addition to that, were there letters from people who know you?
there were longtime friends and a gentleman who had been working with me on the 12-step programs.
Okay. And I would assume that you are appreciative that these people have stuck by your side.
I am. It's remarkable.
And I mean, you understand the gravity of this offense.
Most definitely.
You understand why it's illegal.
I do.
And you're not saying that this is not a big deal or a victimless crime or anything to that effect, are you?
Not at all.
You, as part of the deal and part of the conviction on this offense, you are going to have to be registered as a sex offender if and when you ever do leave prison.
Yes, sir.
Okay. And you intend to keep up with your treatment and sobriety even after you're released?
Yes, sir.
And
I want to maintain sobriety. I don't want to ever go back into this at all.
okay. And it does look like the measures you've taken have helped you to maintain that.
They help me keep sober and keep my focus and not stray into perversity. And
okay. In addition to that treatment, what kind of health issues do you have?
I have diabetes, and I have some mild hypertension and occasional asthma and arthritis.
Okay. Are you on any kind of medications right now?
I have several medications that I take,
Okay.
both for diabetes and for my hypertension.
Okay. And all those are listed in the PSI, correct?
It should be, yes.
Now, Lynn, what are you asking the court to consider in this case?
I'm guilty, so I understand that there needs to be consequences for that, but I just ask that they be reasonable. That you take into the fact that this is my first offense. I've lived a good life. I've worked a good job, tried to take care of the people who have disorders and help them to get better.
And let me stop you there. You've been on bond for quite a while in this case.
I have since February or March of last year, I think.
Okay. And we've had no bond violations or issues with that.
I'm sorry.
You've always showed up to court when you needed to.
I have shown up.
Okay.
On my due diligence.
And so you're asking the court to consider something closer to the 15-year range.
I think that would be fair. That would be in keeping with what I've done.
But I mean, you understand that prison time is appropriate in this case.
Yes, sir.
Okay.
I understand. There's a consequence for bad actions.
Okay.
Breaking the law.
I'll pass the witness.
Any questions?
Mr. Ryan, when did you start seeing a therapist for your issues?
Right after I was arrested, or they had searched my home, I realized that I was in trouble and I needed to take care of my problems. So I saw a therapist first just for emotional disorder, and then I was referred to a sex therapist, certified CSAT, I believe is what.
And when you were looking at this material, you said you started out with pornography, but then you started getting into other things, and that other things included child pornography, correct?
That's correct.
And when you were searching for this information on the internet, you had to learn all of the new terms and all of the ways to look this stuff up. It's not just widely available, right? You have to have the right terms, correct?
Well, you kind of have to know where to look, and the search parameter.
So you use Bing and Chrome on most of those searches?
Not Bing or Google or whatever the search engine was.
Among the things you searched for, that included sex tourism, child. Is that accurate?
I did look at that. Just to see what that was.
Absolutely.
Other questions?
All right. Thank you. I'll hear brief argument. State.
Judge, the content of this defendant's electronic devices, this wasn't minimal casual viewing. This wasn't a one-off. This was intentionally collecting material of not one child, not two children, hundreds of children. There were over 800 images identified, and a estimate of what was probably on that device was 1,200 images of child pornography. In addition to those images of child pornography that were found, tagged, and identified, when the officers searched his home, they identified a book that was signed, had something to the effect of someone with similar interests. It was titled Daddy's Girl, and it described grooming and sexual abuse and exploitation. Judge, it's a horrendous offense. The punishment range is what it is for a reason. I would ask the court to follow the plea agreement sentence under the map.
All right, defense.
Judge, I mean, there's no excusing this behavior. And as Mr. Warren himself has told you, prison time is appropriate. But we do, I'd ask the court to consider the fact that he is pushing 7 years old. He has no previous history. He has health issues. And whatever the court gives him, the vast majority of his life expectancy is going to be spent in prison. The reality of it, Judge, is that we have people in this county that are on probation who have admitted to touching children. We have people deferred in this county who have engaged in possession of child pornography. And while that wouldn't be appropriate in Mr. Warren's case, we'd ask the court to consider the 15 years. I mean, 15 years is not 15 months. It's not a year. It's not probation. And it's an aggravated offense, so he's going to do the vast majority of that 15 years. Given the circumstances in this case, the fact that Mr. Warren very quickly after being discovered, got into treatment, has stayed away from this, and has maintained his sobriety in this case. We're asking the court to consider giving him 15 years in this case.
All right. Mr. Moran, I want you to know that I've listened to everything that your attorney has said. I reviewed the documentation, and I think it's great that you're on the path that you're on, and I hope that you stay on the path. But this was a lot of images and a lot of searching for images. The court, as previously stated, is finding you guilty. The court is going to sentence you to the 30 years in the prison, give you credit for any time served. There's a $5,000 fine, time and money to run concurrently. There'll be Chapter 62 registration. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
I'm sorry, say it again.
Did you review the trial court certification?
Whether or not you have a right to appeal.
Oh, yeah. Yes.
All right.
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you need an explanation of what that means, you'll need to speak to an attorney. Do you understand? All right. Good luck to you. Okay. Thank you.
Really, I think I've already talked to defense. They have no objection, and I got it filed stamped in the back. I'm just asking the court to sign this motion for forfeiture of that book. The OAG's office wants to utilize it for educational purposes for training officers.
Any objections?
And I can get it to you later when
Okay.
Maybe.
Yes. All right, everyone. We're taking our recess.